in turn. Thank you. And can we start with questions from Anam Kesar, please?
Thank you, Chair. Thank you so much to the panel for joining us today. Lord Faulkner, I'm going to come to you first, if possible. I'm looking just to tease out the legal differences between a Section 33 and a 35.
Section 33 covers a situation where the Scottish Parliament passes a bill or an act which is outside its competence because it's a reserved matter. So oversimply, they passed an act that purported to deal with, for example, UK national benefits. That would have no impact. Section 35, on the other hand, deals with a situation where it passes a bill which is within its competence, and nobody disputes it's within its competence to determine the conditions for a gender recognition certificate. But first of all, the way that operates on reserved law, in the opinion of the Secretary of State, causes harm. Nobody disputes in this debate that equalities, whether you're applying them in Scotland or England, equalities as defined by the Equality Act 2010, is a reserved matter, and therefore, in order for a Section 35 certificate to be given by the central government, UK government, it's not enough that it's outside the competence, because it's plainly within the competence. You've got to say it affects the application of equality law in some way, and it's bad the way it affects it, in the opinion of the Secretary of State.
Again, do you think that's the reasoning why the UK government at this point chose to go down the route of a Section 35?
They couldn't go down the route of a Section 33 because it was within the competence of the Scottish Parliament. They, in my view, wrongly, in Michael's view, rightly, Naomi and Robin have different views in relation to it, but in my view, they've exercised their power under Section 35 in a way that they can't. Michael thinks it's okay, I don't think it's okay, but I think maybe, in a way, the way one gets to the conclusion on that is one looks at what's the practical effect of what the Scottish Government have done.
Yeah, so I want to tease this out a little bit more. You've quite rightly had an overview on how Section 35 works. And when I'm looking to talk to you about the engagement and the process of engagement between the two different legislators, so it's my understanding that at no point in the UK government asked the Scottish Government to change the bill. They didn't participate in the public consultations. They didn't write to the Equalities Committee in the Scottish Parliament, and they didn't raise the concerns in writing or in meetings with Shona Robinson, the Cabinet Secretary, before December 2022. Is that normal practice?
Well, I have no idea what the engagement between the Scottish Government and the UK Government would be. When we were passing Section 35, and this was made explicit by the Minister proposing the provision, the impact of using Section 35 would be so serious that we would expect, and this is what the UK Government said when passing Section 35, that Whitehall and Holyrood would engage and reach solutions. But I have no idea what the factual position is as between Holyrood and Whitehall in relation to this particular bill. But the expectation, because Section 35 existed, so if the UK Government was thinking of using Section 35, and obviously they'd be following the bill going through Parliament, you would have expected them to engage with the Scottish Government to work out what the solution was.
Okay. The 2023 Memorandum of Understanding between the devolved administrations and the UK Government states, if formal intervention should become necessary, the UK Government will, whenever practicable, inform the devolved administration of its intentions in sufficient time to enable that administration to make any representations it wishes or take any remedial action. It also says, and you've kind of alluded to this before, is that powers such as the Section 35 order should be seen, and I quote, as a matter of last resort. Is it fair to say that in this case the UK Government have not used Section 35 as a last resort and they've essentially just pressed the nuclear button?
Well, they've exercised Section 35 at the point that Mr Alistair, Secretary of State, exercised Section 35. He said he was willing to listen to discussions to try and change the bill. I assume that's what he was referring to. So there must be scope for there to be further discussions between the UK executive, because it's the UK executive that used the power, and the Scottish Government, the Scottish Parliament, to try to reach some agreement on what changes could save the bill. It's not too late.
Can you talk to me about what good practice is around Section 35? Most people, I think, out there wouldn't have heard of Section 35 or 33. What's good practice in regards to it?
Well, I don't know whether or not, and I do know that Section 35 has never been used before. So I don't know whether or not Section 35 has ever been contemplated before. So I would imagine practice was either non-existent or a bit rusty in relation to it. I think that as far as my experience in government is concerned, between 1998 or 1999 when the bill came into force and 2007, there was never any question of Section 35 being used. Overall, the practice should be, if there's any chance of Section 35 being used, there should be intense engagement between the two in order to try to work out a way whereby it doesn't have to be used, because it is not good for devolution that Section 35 is used. Okay. And actually, there's a broader point. I think both, as it were, women and transgender people expect politicians to reach a solution in relation to a difficult issue like this, and we politicians have manifestly failed to reach a solution.
Thank you for that. I'm conscious of the fact that you've spoken for a while now, so I will give someone else a chance. Michael, if I can come to you, please. There's a quote that's used quite often on a day-to-day basis that you see out in protest rallies or people just post on social media, and it's quite simple, are trans rights human rights? Would you agree with that?
I think there is a difficulty with that in the sense that the identification of a trans person doesn't appear anywhere in UK law, with the exception of something like gender reassignment. So the status that we'd associate here in terms of anti-discrimination rights on the basis of a protected characteristic of gender reassignment, that could be a catch-all term for trans rights, those anti-discrimination rights. But the other rights that we would be talking about would require us to look more directly at the nature of the rights themselves to see whether they would be within the ambit or scope of human rights provisions as they exist within particular regimes like the ECHR or the UN or something like that.
I was expecting a yes or no answer, but you give a politician's answer there.
Well, a lawyer's as well, yes.
Yeah, a lawyer's answer as well. Let's tease it out a little bit. So in 2017-18, former Prime Minister Theresa May pledged reform, and she said transgender people across the UK find the process of legally changing their gender overly bureaucratic and invasive. She then added that she wanted to see the process, and I quote, more streamlined and demedicalised, because being trans should never be treated as an illness. Would you agree with that statement?
That being trans should never be seen as
an illness, and that there should be more streamlining in terms of reform?
I think, again, this comes down to the definition of being trans. Someone who suffers from gender dysphoria has a medical condition. Beyond that, the legal conditions or the legal tests that might be associated with this will change depending on how legislation or regulation is brought in. The current UK system does have a medicalised process here that says you can change your legal sex if and only if you have been diagnosed with gender dysphoria.
Looking at the UK government, so this is obviously previous commitments from the UK government, from a former Prime Minister. We're now, I can't count how many Prime Ministers on are we, there's 3 or 4 Prime Ministers since Theresa May. Do you think this is something that the UK government should be pursuing, reform over GRR?
I'm not sure if that's something that I would be able to comment on in a legal capacity, no.
So I read your paper that you recently published, the Scottish Gender Recognition Reform Bill, the case for a Section 35 order. I actually saw it was published on Policy Exchange, which interestingly is a think tank that's been hailed by the Telegraph as the largest but also the most influential think tank on the right, and founded by Michael Gove. The crux of your argument in this, in your article, which, and to bear in mind that the bill did pass on a cross-party basis in Holyrood, is that it merits a Section 35 order. You raised concerns over the Equality Act. Concerns have been raised, and one of the concerns that people discuss is over single-sex associations being required to admit people with a GRC. But that already exists and precedes the GRR bill. This has not just come into force over the last month or so. So if these issues already exist, could it not be argued that the Equality Act isn't being modified?
The provisions of the Equality Act are not being modified, and I don't think anybody has argued that the provisions are being modified. That's not the test that's needed for Section 35. It's the operation of the Act that matters here. And so, in terms of the question of what are the reasons that would justify a Section 35 order, some of those reasons will be related to things that currently operate under the GRR bill already that might be considered to be problems if they were changed substantively. Others will be new concerns. So there will be legal concerns in relation to schools that are just very, very unlikely to arise in context where you do not have minors changing their legal sex. But the main provision or the main concern here in terms of the justification for the use of a Section 35 order will come to both practical effects and legal effects. So altering the substantive nature of those who can change their legal sex. So removing certain requirements, removing all third-party requirements to validate or to ensure that the procedure is not being abused could result in certain problems.
So you've spoken now about the process being abused, but would you not also agree that the numbers are interesting? I think Lord Falconer had referred to it in his Twitter thread. I don't know how often Twitter threads are referred to in committee sessions, but in his Twitter thread he spoke about how there's around 30 people right now in Scotland, and with the GRR reforms that would increase to around 250 to 300. Is there going to be abuse of the system?
Well, 2 points to make on that. The first point is that some of the numbers analysis that Lord Faulkner has done has been challenged separately from a policy group, Murray Blackburn and Mackenzie. And so there might be circumstances where the numbers really do matter. And we really don't know at this point what the numbers are going to be, and the fact that we don't know might itself be grounds for consideration of reasonable grounds in relation to the Section 35 order. But even separate from that, even if no numbers are dramatically changed, there's still going to be changes to the legal operation here. And those legal changes that are going to be happening, the expansion of the category itself, there's arguments to be made that itself will have issues. And so the concerns about ensuring that any third-party verification that this will not be abused will be removed.
Could I just come in on the little swipe at me on the numbers?
Have you finished on that numbers point, Mr. Foran?
The numbers point, absolutely, I finished on that, yes.
Caleb Faulkner.
In the Twitter thread, and the basis on which I've come to these conclusions, I have used the numbers that were used by the UK government. And the UK government's numbers were 500 to 550. So that was their outer limit per year. So that, I mean, the British government's got to have some number in its mind, and that's the number that they've got. So I think one should treat that as the sort of outer limit. And the way that the UK government came to that number is they compared the closest country that had self-identification, which I think was Ireland, and on the basis of what had happened in Ireland, that's they came to it. So I think, with the greatest respect to Michael, the attack on the numbers doesn't get very far.
Yeah, and I don't think it needs to either, because the concern is not just about the numbers. The concern is going to be about the change to legal categories, the change to the operation of the Equality Act, the change to the operation of single-sex schools. These are going to change regardless of whether or not it's one person or 500 person or 25,000, which is the number of trans people in Scotland.
I think I hear what you're saying. I think people also need to be mindful of sometimes with the conversations that are being had, it sounds as if it's going to be thousands upon thousands by thousands of people that are looking to change their gender, and from what I've seen, that doesn't seem to be the case. Sticking to numbers, it seems to have a bit of a theme going on here. Stage 2 of the bill that went through the Scottish Parliament had an amendment, a clause, so new clause 15A. It was supported by the Scottish Government and brought forward by Labour MSP Pam Duncan-Glancy. And she states, for the avoidance of doubt, nothing in this Act modifies the Equalities Act 2010. I'm going to come and just ask you your thoughts on this, and then Naomi, I'll come to you at the end, because I know that you've written about this as well. Robin?
Well, that, I think, flows from the difficulty that had occurred between the Scottish Parliament and the UK Parliament over the women on public boards provisions, which had been enacted before and were initially ruled to be without the competence of the Scottish Government. And then a new set of guidance was produced where it was being made very clear that the Scottish Government were not changing definitions that were relevant to the Equality Act. And my understanding of why 15A is there was to emphasise that point relative to the work on the GRR. I don't think there were particular areas that it was focused on. I think it is a consequence of the public boards legislation fracas that had occurred before. I sat through a lot of the proceedings in Scotland and have talked to a number of the legislators in Scotland, and that's my understanding of where 15A comes from.
Lord Falconer, you got any comment?
I think it's wider than that. I think the purpose of, I think it was a Labour amendment adopted by the Scottish Government and therefore passed, and the purpose was to underline the point, because you didn't need it, but it underlined the point that none of this, as Michael is saying, affects the legal tests that apply under the Equality Act. And the key thing, your happy moment.
I will.
The key thing is that when you're talking about, for example, safe spaces, neither the Gender Recognition Act 2004 nor the Gender Recognition Act Reform Scotland Bill 2023 affects the fact that what you've got to do to determine whether you can exclude somebody who is a trans woman but is the subject of gender reassignment protection, you've got to make a decision if you're, for example, running the prison or running the safe space, whether or not excluding that person is proportionate to a legitimate aim, and the legitimate aim is to protect either her or other people in the safe space. Whether she has got a gender recognition certificate makes absolutely no difference to that whatsoever. And the effect of the passage of the bill in Scotland was not to change the proportionate means to get to a legitimate aim.
Michael, you want to jump in?
Yes, so I think the term modification here really matters. If what we mean by modify is that no provision in the Equality Act is repealed or replaced, that's obvious. It's true and it's trivial. If modification speaks to the legal operation of the Equality Act, then there will be a modification to the Equality Act here. There absolutely will be. Because what you have done with relation to the relationship between the Gender Recognition Act and the Equality Act is that you've granted somebody the ability to change their legal sex if the Lady Haldane judgment is correct for the purposes of the Equality Act. And so an analogy here might be any of the rights and provisions that are protected within the Equality Act that are assigned exclusively to, for example, women, they will remain broadly the same. And the mechanism by which you gain access to those, a gender recognition certificate, consider that a lock of some kind, that will remain broadly the same. What the Gender Recognition Reform Bill will do is it will give a lot more people keys to that lock. And it will not just give in terms of numbers, it will give people who previously under the current UK system do not have and cannot have access to that. It will give people who do not have a diagnosis of gender dysphoria access to that status. And in terms of the single-sex services, spaces and associations, the operation of those tests is going to be altered significantly. The tests themselves will remain the same. Okay, so the tests for single-sex services says that you can exclude somebody on the basis of either sex or gender reassignment in circumstances where it is justified as a proportionate means of achieving a legitimate aim. The legitimate aim here remains the same for the setting up of these services. The test remains the same. But if you have a gender recognition certificate, that will be a relevant factor to take into account when determining whether or not there's been a proportionate means used to achieve that aim. So if you are legally and biologically male and you want access to a female-only space, you will have certain factors there that it would make it easier for exclusion than if you are a legal woman. a legal woman requiring access to a women-only space, the test will remain the same, proportionate means of achieving a legitimate aim. But whether or not it is proportionate to exclude a legal woman who has gender reassignment as a protected characteristic is going to be different than whether or not it is proportionate to exclude a legal male. Okay. Now, for associations and schools, again, the tests remain the same, but there is no provision for associations or schools that permit you to discriminate on the basis of gender reassignment. So if somebody changes their legal sex to become the legal sex of that school, they will be entitled by right to have access to those associations and schools, because failing to provide them with that access is direct discrimination on the basis of gender reassignment and would be unlawful. So getting access to those certificates.
List by other panel members who are specifically going to come to these points. So I'm just going to move on to Naomi. Now, you wrote about this in your blog about New Clause 15A, where you examine it in regards to the Equality Act. And you made reference to that kind of door and lock analogy that others have spoken about. And you say, what the bill proposes to do, and at least arguably can do, is manufacture thousands of extra keys to the door and hand them out to pretty much anyone who says they'd like one. You're talking about numbers in the thousands. Lord Falconer has spoken about hundreds. He's just referred to the fact that he uses data from the UK government. Can you evidence your claim, please?
The numbers don't ultimately matter, whether we're talking about
That's what I'm asking about,
or thousands.
I completely understand. I'm asking specific.
I'm a lawyer, not a sociologist. So I don't know. The Scottish government doesn't know, the UK government doesn't know what the numbers are going to be. What we do know for a fact is that the bill radically changes the eligibility criteria for being given a copy of this key. We don't know how many people, but we do know that there is not going to be any medical requirement. There's not going to be any need to evidence living in the opposite gender, whatever that's supposed to mean. And we know, or we can predict with some certainty, and events of the last few days should have taught us that the profile of the cohort who will get access to these keys will be very different. It won't be the tiny minority. If you look back at Hansard to see the debates around the time of the original Gender Recognition Act, it's emphasised over and over again that what we're doing is making humane provision for a tiny minority of people with a very distressing medical condition. That was the intention of the GRA. And what we're now looking at is handing out gender recognition, and also in that intention and in that expectation was a picture of the typical man who identifies as a woman, and it's always that way round, not women who identify as men, that create or almost always, that create the really acute issues here for obvious reasons. All of that debate was predicated on an image of a man who identifies as a woman, who passes, who has had all the surgery and all the hormone treatment that medical science can provide him with, and who is desperately unhappy, has been for years desperately unhappy with his physical body, and has done everything he possibly can to assimilate as a woman. And I think the mental picture, when that legislation was passed, was of someone who would not cause any upset in a women-only changing room, in a women-only toilet, in a women-only ward, in a women's prison, because everyone would just accept that he was a woman. Everyone would think he was a woman. Events of the last few days should have made it vivid to everybody that that's not the cohort that we're dealing with now. We're dealing with a radically expanded category. The trans umbrella is now taken to include people who cross-dress for a whole variety of reasons. There is nothing in the provisions of the bill as drafted that will stop men who cross-dress for erotic purposes, from gaining GRCs, who cross-dress for the purposes of avoiding being sent to a men's prison when they've committed horrible crimes and think they'll have a nicer time in a women's prison. Or you simply enjoy the exercise of power that they feel by transgressing women's boundaries. There are no controls that stop those people. So we don't know. You don't know. I don't know what the numbers are going to be.
Well, I hear what you're saying. But some people would argue that it's not necessarily the case that anyone who's going to go through the process to gain a GRC would be predatory. And
I wouldn't suggest for a moment that everyone who goes through the process is going to be predatory.
predatory men or predatory
The problem
women.
is the other way up. The problem is not that everyone who wants a GRC is predatory. The problem is that there is nothing in the process proposed to stop predatory men like Isla Bryson from getting a GRC and using it to terrify services that might want to say, no, this is a women-only space, because it makes the legal route, at the very least, and I think Michael and I part company slightly here on the legal complexities of how the single-sex exceptions operate, but on any view, it makes it more complex for service providers or for people like the beauty training course that Isla Bryson went on. It makes it more difficult for them to say, no, this is for women only, or no, you're not allowed to partner with a young female classmate in order to apply fake tan to her in the most intimate way, because he's got this magic certificate that says, A, he's a woman, and B, nobody's allowed to mention the fact that he's really a man.
Okay, so you're talking about predatory, like we're having a discussion about predatory men, and quite rightly so, there has to be provisions in place to protect women and girls. In front of me here, I have...
Voted down though, weren't they?
Pardon?
Those provisions, amendments to achieve that were voted down.
On a cross-party basis, it was passed. So I've got a statement in front of me from, I think it's 15 different women's organisations. You may have seen it. It's from signed by Amnesty International, Back of Scotland, Close the Gap, Crew and Gender, and a few others, including Scottish Women's Aid, Scottish Women's Convention, and the Scottish Women's Rights Centre. There's a particular line that stuck out to me. And during this whole debate over the last few years, something that I quite remind myself quite often, there are, and I'm just quoting from it, there are currently a number of very real threats to women's rights in Scotland and the UK, including but not limited to poverty, the cost of living crisis, cuts to services, rape conviction rates, and the experiences of immigrant and refugee women. We find it particularly concerning that so much political and media attention has been devoted to the debate around this bill in place of tackling these genuine barriers to women's equality. Would you agree with that statement?
That is, I think, the rhetorical manoeuvre generally known as whataboutery, which is to say, you're not allowed to care about this important thing until you've fixed all these other important things too. Of course those things are important. But I also think that it's important that women should have the right to ordinary, everyday privacy and dignity. Not just women from particular faith backgrounds where it's especially distressing for them to be expected to undress in the presence of men or to use the toilet in the presence of men. Not just women who've been traumatised by rape or other sexual violence, but all women are entitled to their own boundaries. And I do think that's important, and I'm not going to be deterred from saying that's important by saying, do you agree that lots of other things are important too? Yes, many, many things are important.
And of course, at the same time, the rights of trans people, immigrant people, people from different marginalised communities is incredibly important. Going back right actually to the start of my original question was around the numbers. And sorry, it's just escaped my mind. Were you able to evidence that the thousands of people?
Which thousands?
When you said what the bill proposes to do, and at least what arguably can do, is manufacture thousands of keys to the door and hand them out to pretty much anyone who says they'd like one.
As I said, the specific numbers aren't particularly important. I can't tell you, no, I haven't done the research, I can't tell you it's 10,000, it's 20,000, it's 900.
Okay, that's what I was just looking for.
What matters is the cohort and the profile of the cohort and the withdrawal of the controls.
Yeah, okay. I'm going to move on. My final question directed to the panel. Robin and Michael, I'll come to you first. Surely it can't be the case that the UK government doesn't agree with what the Scottish government has passed. They go to essentially press the nuclear button. Section 35, we've spoken about, should be used as a last resort. What future steps can UK government take to ensure that they're respecting the mandate of the Scottish Parliament and the legislators sitting up in Edinburgh? Because it doesn't really seem right that is the case. That is essentially MPs telling MSPs what to do.
I have an answer from the consultation, which is that, as you'll know, there is a Scottish Human Rights Commission. And originally, the UK Human Rights Commission, at the time when Theresa May was proposing these changes, supported the changes, and have changed their view. And there was a great deal of embarrassment. The UK Human Rights Commission appeared before a similar committee in Scotland and could not explain that change. And the Scottish Human Rights Commission were asked that same question by the Scottish legislators. And their position was, if there's going to be such an enormous change of position from it's okay to it's not okay, then there should be some explanation. And there never has been.
I think it's worth noting that the Equalities and Human Rights Commission refused to attend today. Anna.
Michael, would you like to add anything to that?
They did attend in Scotland, but I'm afraid to say their chief executive, in my view, won the pen twiddling competition of the year when she was asked that question.
So I might start by answering this question by maybe setting out my understanding of how Section 35 operates, and I think maybe to challenge the contention that this is a nuclear option, because the two things that are relevant for here. The first thing is that what the effect of this is that it pauses the bill from getting royal assent. It can be reintroduced at stage 3 at any time. It opens the door for negotiation that would not be possible if Section 35 had not been used, because you have that 28-day period that cannot be paused or stopped unless Section 35 can be used. The reason why, in my view anyway, there was not cross-governmental discussions over this is partially because the Lady Haldane judgment dropped literally days before the final reading of the bill. And that will have changed the assessment, the legal assessment that the UK government would have gone into. And the bill had 150 amendments to it. They didn't have a final version of the bill up until the very point that the only option open to them at that point would have been to use Section 35 or Section 33, but I think both myself and Lord Faulkner agreed that Section 33 would have been inappropriate in this context. So looking at it from that perspective, then moving into, okay, what can be done? The answer to that is going to depend on what the Scottish Government wants to do with regards to this legislation. What are its goals? What are its purposes? If the purpose here is to affect the law for reserved purposes, then it's going to have difficulties. It's always going to have difficulties there. If it only wants to affect the law for devolved competencies, then it will have an easier time to do that. But the question is whether or not it wants to do one or the other, and I can't make a judgment on that. What I will say in terms of the idea that Section 35 is a nuclear option, I'd say I would agree with Lord Hope on this, who's a former Supreme Court Justice who, when asked on this, said, yes, this is an extraordinary use of a power, but it's also an extraordinary piece of legislation. It's an extraordinary bill that has come through. We have, even if you compare self-ID laws that have been brought in the rest of the world, they have never tried to bring it in by hooking onto and amending a piece of legislation that would then have effects for a broader piece of legislation that operates at a jurisdiction that the lawmakers did not have authority to make law over. The reason why Section 35 was used in this context is because of the way that the Gender Recognition Act affects the Equality Act. If you change or modify the Gender Recognition Act, that could have effects on the operation of the Equality Act. And so the organisational decision-making that's going to be done between governments is going to have to first decide what each government wants to do in terms of its purposes here and what it wants to do in terms of the effects that it's willing to have on reserved areas.
Thank you so much. And final question to Lord Faulkner, because I know that other colleagues want to come in. So this piece of legislation was, of course, an SNP manifesto commitment, but it did gain cross-party support with 2/3 of MSPs voting in favour. It was the most widely consulted piece of legislation in the history of the Scottish Parliament. So how can it be the case in a democracy, regardless of what your views are on GRR, where we have a democracy, there's a devolution settlement in place, that we are sat here today in House of Commons discussing its legitimacy?
Well, Section 35 was passed by this Parliament because it envisaged that there could be circumstances where you needed to say no. These circumstances are not the ones to which Section 35 was going to apply.
Thank you.
Michael, can I just take you back to a comment that you made, and indeed a comment Naomi made, where I think, Naomi, you indicated that the numbers didn't matter, and you, Michael, said that there were some circumstances in which they might. Mm-hmm. Can you expand on which circumstances?
Well, numbers are going to matter if they get large enough in a lot of areas. There are going to be some circumstances where even a change in the law here will be the legal effect that matters. So there will be circumstances where if many people get these certificates, the profile of those people we're not going to know. We're not going to know whether or not those people are going to be people who have gender dysphoria because we've removed the requirement for that. We're not going to know if the people who get a gender recognition certificate are doing it for fraudulent reasons because we have removed requirements. Profile,
you're suggesting, matters, not the numbers?
Well, it's both. So if the profile contains a percentage of them that are doing this for fraud, and then the numbers shoot up, you're going to have a lot of people doing this for fraud. Now, there are going to be some circumstances where the numbers are not going to matter because the legal changes that are happening here in terms of the law in relation to associations or services or schools will be such that it would create such uncertainty for those services that they may adopt policies that they might not otherwise adopt in certain circumstances. There's also going to be circumstances where, and I know this has been discussed as an issue that really shouldn't be seen as an issue, but there is an issue in terms of IT infrastructure here if there is a distinction between Scotland and the rest of the United Kingdom in terms of what legal sex you are. Because for a lot of IT infrastructure, there's only one option to do that. And if the UK government says that's going to be a massive bill that's being put on our feet there's going to be circumstances where they will say, in that context, whether or not we're foot with that bill is going to be something that warrants our input at some point.
Are we really saying that gender recognition comes down to the cash? Is that what you're saying?
Well, no, I'm saying choices about the cash have to be made on a cross-party and also at a cross-governmental decision-making.
Okay, thank you. Can I take you all, perhaps?
Can I possibly come back to that question, since you mentioned me in relation to...
You did say numbers didn't matter.
The specific numbers don't matter. The orders of magnitude do matter. So we don't know whether the Scottish Government's estimate of the order of magnitude change when this bill, if and when this bill ever comes into force, brought about by it, is that applications and grants of gender recognition certificates may go up tenfold. We don't know if it's tenfold or fivefold or 20-fold or 50-fold. We simply don't know. What we do know is that there is likely to be an order of magnitude change. So will be a lot more. We don't know how many more. We can't at the moment.
I'm sorry.
Yeah, but can I just... So, numbers don't matter, but order of magnitude does. Is that what you're saying?
Specific numbers.
Administratively?
Because what you're looking at doing is radically changing the way this piece of legislation operates. It was a piece of legislation that was sold to Parliament in 2004 as directed to a tiny minority, and this was said in debate over and over again. It's a tiny minority. It's a tiny minority of people with a very distressing medical condition. And what almost everybody thought at the time was it's not going to have much impact on society as a whole. Once in a while, a man who passes as female will use a women's toilet, a women's changing room, and women in that facility will either pretend politely not to notice or even possibly in some cases actually not notice. But it's all going to happen on a tiny, tiny scale, and it's not really going to matter. And the same goes for the effect on statistics. As things stand at the moment, the courts have held that when the census is taken, what has
I simply don't
recorded
have
is legal sex.
Okay, and I think you've made that point. Robin, did you want to come in on that?
Yeah, we actually, I mean, the good thing about the recent census is we've started to get some figures. And it would appear that there is one trans person in every 704 in the population. That's emerged from the recent number crunching of the census. It perhaps is still an underestimate because people are still reticent, perhaps, of declaring themselves to the state in terms of numbers. So that perhaps is a handle on how rare we're talking about, broadly 1 in 1,000, 1 in 700. So the rampaging wildebeests implications of trans people doesn't seem to run from this corner of the bench.
Can I just take you on to the Haldane judgment? And can I ask a question about timing? And actually, I don't know that I mean timing, I think I mean time. What pressure, what additional pressure did that place on the UK government when it came to what I suspect was the Secretary of State feeling that he had no choice but to use Section 35? Perhaps you can answer that, Lord Faulkner.
I don't think it makes any difference, to be honest. I think the Haldane judgment said that where you have a gender recognition certificate, whether it be one under the old law or one under the new law, you are a woman, or the gender, your acquired gender, quote, for all purposes, except where there are exceptions, and the exceptions still applied. The British government, in their reasons, don't actually treat that judgment as applying to the whole of the Equality Act. They say that there are bits of the Equality Act where sex may mean biological sex. It's not clear that they're accepting it. But assume that a gender recognition certificate makes you a woman or a man, depending on which gender you've acquired, quote, for all legal purposes. It doesn't make any difference, in my view, to whether or not you should use the Section 35 power. Both Kemi Badenoch and Alistair Jack, when they were saying why they used it, were saying it was to protect women and girls, and both of them said that. There are other administrative stuffs around the edges, but that's the key, which is essentially the safe spaces issue. The safe spaces issue is not affected by the Scottish Bill. And you can see that it's not affected by the Scottish Bill by the way both countries have approached the issue of transgender women in the female prison estate. In October 2022, the Lord Chancellor, I don't know whether it was Brandon Lewis or Dominic Raab, it's very difficult to keep up with these changes, he made, whichever he was, made an announcement saying that from now on, transgender women, if they had male genitalia, would not go to the female estate. No mention of GRCs at all in his announcement. It was just a practical announcement. The Minister of Justice in Scotland have made exactly the same announcement yesterday. Which you go to does not depend upon a GRC. It was difficult to listen to Naomi and Michael constantly using the key analogy, suggesting that getting a GRC on this lower basis is a key, for example, to a women's prison for a transgender woman. It is not. It is looked at on a case-by-case basis. Could I very, very tentatively suggest a solution to this problem, which is, suppose, this may be a fantasy world, that the Scottish government and the UK government, supported by their Human Rights and Equalities Commissions, agreed on what the principles were in protecting safe spaces. For example, they agreed that it's done on a risk assessment, that having a GRC is not, as Michael and Naomi were suggesting, a key to a women's prison if you are a trans woman. It depends upon the risk to you and the risk to everybody else. And if that was made absolutely clear beyond doubt and certain principles were agreed, then there would be much greater confidence, particularly in a lot of women who will feel genuinely frightened about what may happen in the light of the recent example in Scotland. But that is not caused by the Gender Recognition Bill, it's caused by an ineffective risk assessment process. So make the law clear, get the two governments to agree on what it is, because there isn't much disagreement on what the law is, and say this is the way to protect safe spaces, even if you make it easier to get a gender recognition certificate. All three parties, Labour, Tory, SNP, have agreed that the gender recognition requirements for a gender recognition certificate should be relaxed. This committee has called for it because the evidence is pretty overwhelming that it's cruel and isolating the way it works.
Don't forget the Greens.
And the Greens support it as well. Do reduce the requirements. Make sure there is the right protection. The right protection comes from what the law is at the moment. You don't need to change it. That's why the Section 35 certificate is wrong. Get the two governments to agree that, and there could be a way forward in relation to it.
Can I come back in?
If there were, can I just finish with Lord Faulkner, and this could be a yes or no. Would it be helpful if there were a definition of sex in the Equality Act?
There already is one.
There is an understanding of it. There's not a specific definition.
So sex is if you're a male or a female, and then the definition of man is or if you're a man or a woman, and then the definition of man is a male of any age, and the definition of a woman is a female of any age. They have the definition, but they don't have clarity.
Haldane judgment interpreted that differently.
Yes, it did. So Haldane,
following the Haldane judgment, would it be helpful if that were revisited?
I think absolutely. The issue with the Haldane judgment as it arises for all of the purposes that we're dealing with here is that up until that point, we were really not sure whether or not sex within the Equality Act, as modified by a GRA, whether or not, it actually does modify the Equality Act for the purposes of the claimant. So somebody who has a gender recognition certificate, whether they would be classed as male or female for the purposes of a direct discrimination claim. What the Haldane judgment does is it goes further than that, because it effectively says that the definition of sex in the entire Act becomes legal sex. And that means that single sex spaces become single legal sex spaces. And what it means then is that your justification for exclusion will hinge partially upon whether or not the person is of the characteristic legally that space is. Now, the test is the same. It's still proportionate means of achieving a legitimate aim. But whether or not you are legally the same person of a space or a service that is set up for that legal category, not biological category, will be relevant for determining whether or not exclusion is proportionate.
Right. Lord Faulkner, do you want to comment on that?
I think Michael's making it incredibly complicated. It doesn't change. The Gender Recognition Reform Bill does not change the basis on which you make a determination on whether or not...
No, it changes whether or not you can sue. So the policy arguments will not be changed. You could introduce a policy that bans all males from female prisons if you want, but you could be sued for that. You could be sued for gender recognition discrimination. And the question about whether or not you have a gender recognition certificate changes the nature of that suit that you make from an indirect discrimination claim to a direct discrimination claim, subject to the same justification test. Is it a proportionate means of achieving a legitimate aim? But if you think a court will possibly come to a conclusion that the exclusion of this legal woman who is biologically male is that there is a less onerous way to achieve the legitimate aim of providing security, then the policy will be struck down as unlawful. So if you want to ensure with absolute certainty that no rapist makes it into a woman's jail, you need a blanket ban. And blanket bans can be struck down by courts. You need to legislate to have that ban in place. Policy documents, guidance won't do it because the legislative framework is as it is, and it's hooked onto a proportionality test.
Elliot, did you have a question you wanted to...
Could I just come back? Michael slightly cut me off.
Yeah, sorry, I apologise for that.
That was so misguided, what he said. Can I try and make this sort of real for... Suppose you were the prison minister, as I was, in relation to this. You've got to address this on a factual basis. Doesn't matter whether you've got a gender recognition certificate or not. You've got to work out whether it's safe for somebody, and that is exactly the way the courts will approach it. This idea that the GRC is going to make the difference is complete academic nonsense. The prison minister has got to address himself to the question, what's the basis upon which I let somebody into the female estate if they are a trans woman. And the recent case in Scotland indicates you'd never let somebody in those circumstances in, and that's the announcement that Brandon Lewis or Dominic Raab made in October. None of this is changed by the Gender Recognition Bill. You've just got to look at it on the basis of the facts on the ground at a particular time.
Can I come back?
Thank you. Yes.
Please? Because I am not an academic. I'm a practitioner of some horrible number of years' experience in discrimination law, and I completely agree with Michael that the possession of a GRC makes it more complex. Lord Faulkner is half right.
Can we please be polite to other witnesses? Thank you, Lord Faulkner.
I apologise. I do apologise.
Thank you. Lord Faulkner is half right in that a gender recognition certificate is not simply an access or all areas pass. And a gender recognition certificate has not made the difference to the Scottish prisons policy because the exceptions that allow service providers, public authorities, employers, schools, etc., to discriminate on grounds of sex and gender reassignment when it's necessary for them to do so are permissive, not compulsory. And it's starting to look as if they ought to be compulsory because they're now coming under so much pressure. But under the Equality Act as it stands, they are permissive, not compulsory. So something like the Prison Service can perfectly lawfully operate a policy that doesn't make proper use of those permissive exceptions, allowing discrimination. The problem comes when a service provider or public authority or whatever wants to do the right thing and provide a single-sex service when it's necessary, and is faced with a man who identifies as a woman who says, that's not lawful, you're discriminating against me. Now, if he doesn't have a gender recognition certificate, the answer is very plain and simple. The answer is, sorry, you're a man. As far as the law is concerned, you're a man. You don't have a gender recognition certificate, you're legally male. So this is a women-only space, a women-only service, whatever. You can't come in. And that is a flat, simple answer. And that's easy. And that's easy for any little service provider to operate. If that same man has a gender recognition certificate declaring him to be a woman, the situation is very different. At that point, it's no longer sex discrimination, which is by definition permitted if this is a lawful single-sex space or service. It becomes gender reassignment discrimination. And then it has to be specifically justified. And we can argue about whether that's necessarily case by case or policy by policy, but it's more complicated. The legal route is more complicated. And that, for a small organisation especially, but we've actually seen for larger organisations too, is pretty daunting. They need to go off and take legal advice. They probably can't afford it. They don't really understand what the issues are. They may well think, faced with a man saying, my birth certificate says I'm a woman, that they've just got to give way and let him in, even if that means that their core users simply self-exclude.
Elliot.
Thank you very much, Chair. I want to bring this back to the legal reality, which is why we've asked you all in today. Naomi, just picking up on the point you just made, do those legal complexities not already exist? Because I think this is what this committee is trying to understand, is that if the UK government is using the effect on a reserved piece of legislation as a reason, if these legal complexities already exist UK-wide, does that not then invalidate the use of that as a Section 35 reason? I think that's what we're trying to get down to the heart of here.
That might, my short answer, I'm going to keep it quite short because I think this is a question better directed to Michael, who's the constitutional lawyer. But my short answer is that this is a situation where the whole impact of gender recognition regime is radically changed by this relaxation of the eligibility criteria. So the problems already exist, but they will be made very much worse. And they will be made much worse not just by what we can reasonably expect to be an order of magnitude change in the numbers affected, but also by what I talked about, the change in the demographic, if you like, profile of the kind of individuals and the kind of reasons for which they will apply for gender recognition certificates.
So, again, coming back to the legal reality of the Section 35 order, the UK government said in its statement of reasons it's willing to talk to the Scottish government to basically find something that would be acceptable. From leaving aside opinions on gender recognition reform whatsoever, what then, in your opinion, would fall into a legally acceptable category of gender recognition reform? Or does the Scottish Parliament, in your opinion, simply not have the devolved competencies to actually do anything in the gender recognition space without the UK government?
That's a question.
Yeah, I could make
directed to
on that.
Michael.
And so what I'd say, just to pick up on the first question, the Statement of Reasons effectively operates on two broad categories. One are existing problems that will be made worse, and the other one is new problems that will be created. Among the new problems that will be created is going to be problems for schools, serious problems for schools. So if you have a gender recognition certificate, you are biologically male and you are classed legally as a woman or vice versa, that information becomes protected information. And that means if somebody comes across that information in an official capacity, it is a crime for them to disclose that. You can see where this could have issues for safeguarding in schools if a 16-year-old...
We've got an entire section on 16 and 17-year-olds. I don't think we're ever going to make it there.
I mean, ask that. Perhaps if I could ask you then the direct question then that I was going to ask later on schools, which is, if that was removed from the Scottish Bill, would that therefore make it legally acceptable? Leaving aside again any opinions on gender recognition reform.
So it would resolve one of the issues in the 13 pages of reasons, but it wouldn't resolve all of them. Now, the question about what can be done, that's partially going to be determined by what each government thinks its purpose is here, what it wants to achieve. The reason why the Statement of Reasons is set out the way it is that the issues that the UK government takes issue with are only those that hook onto reserved matters. And so if there was a clear statement within a bill that says none of this will affect the operation or effect of the laws that applies to reserved matters, that could be an issue. But it could cause political concerns because that might not be what the Scottish Government wants to achieve. The question comes down to what they want to achieve at that point. It is entirely possible for you to produce a bill that will be capable of withstanding a Section 35 order in this context. But it comes down to what each government wants to achieve as a part of it, particularly what the Scottish Government wants to achieve.
Perhaps, Lord Faulkner, if I could come to you, is one of the reasons that we've arrived at this space and we're having this discussion is because the entire UK legislative framework for gender recognition simply is not fit for this day and age. So we've even aside the Scottish law for 1 minute, the interaction between the GRA and the Equality Act has been subject of intense debate, very toxic public debate. Is that not part of the reason that we've arrived in this space? Because now we're deciding on whether or not a Scottish bill has the legal ability to pass. I'm probably not using my words very, very well here. But is that not because actually the UK's legislative framework is not fit for purpose at the moment?
I think that's right. I think the reason we are here is, first of all, under the existing law, there was a lack of confidence in the way that safe spaces were operated. People didn't quite know how it operated, and there were concerns about it. And secondly, and separately, there was real concern about the inadequacy and cruelty of the process by which you got a gender recognition certificate. Your first question to Naomi was all of the problems about the way that the safe space process works. Michael's right, schools are in a slightly different category. Apply under the existing law as much as under the new law. In fact, the new law, the Scottish law, which hasn't yet become law, doesn't really affect the pressure on that. see Brandon Lewis or Dominic Raab's statement in October, he was trying to deal there with the problems about how you operate the existing law. The stuff about, it's all going to become harder is not right. You are right where you say the existing framework is not working. You could make the existing framework work much better if there was a sense of shared acceptance of what the law was, which would be, and you could get it out of this crisis in a way, because it is a crisis about how the law is operating at the moment, by everybody agreeing what the interrelationship between the law on safe spaces on the one hand is and gender recognition certificates on the other. And if both governments agreed what the law was and they were backed up by their Equalities Commissions, that would have a huge impact on it. But I don't dispute your proposition that there is a real problem with the law at the moment.
And it's crumbling in a different way, because nowhere in the paperwork that I've seen relative to today's proceedings is there any mention of anything other than gender dysphoria. Now, one of the world organisations has now moved to gender incongruence, and we have a judicial review in Northern Ireland, JR 111, that now says that a diagnosis of gender incongruence is good enough to grant a gender recognition certificate. And it is becoming increasingly difficult to get a diagnosis of gender dysphoria because the medical world is moving away from that in exactly the same way that we recognise that homosexuality was not an illness but part of life's rich tapestry, and that's the way the medical profession is moving. We will shortly be in a position where people won't be able to get that definition.
There's a lot more that I'd like to go into, but I'm conscious we're voting
running
soon.
out of time.
Chair.
Kate, do you want to ask some questions?
Yes, thank you. Thank you, panel, for coming here today. Before I ask a couple of questions to the panel, I just want to say that I think that many people, including myself, see the government and others playing politics with trans lives and the issues around it. I think the fear-mongering and the hostile environment reminds me of the days that I was fighting Section 28 in the 1980s. I think it's quite regressive and extremely worrying where we are now. My question, if I can ask you, Lord Faulkner, please, the EHRC, who you heard we invited but declined our invitation, their view is that if the UK government were to choose to recognise Scottish GRCs obtained via the reformed system, two systems using different criteria for legal gender recognition will coexist within Britain. Is this correct? Would the Scottish Bill have the practical effect of bestowing one legal sex on a person in Scotland while the same person could have a different sex in a different part of the UK?
Not if the UK government took steps to say they would recognise a certificate, whether it came from Scotland or whether it came from England, then you wouldn't have two systems. Anybody with a GRC, whether it be on the less strenuous basis in Scotland or the more strenuous basis in England, they'd all be treated as whatever the certificate said. But that's not the legal position. The position at the moment is that if the bill in Scotland were to become law, those certificates in Scotland would only be recognised in Scotland. It would need a piece of legislation or some other act by the UK government to have them recognised in England.
And there isn't actually a practical difficulty. I don't have a GRC. I transitioned just before the Theresa May period and was looking forward, like the first same-sex marriage people, to being the first person on the steps to get an English GRC under the new system, and I waited for that. But I practice under my female name. I pay my taxes under my old gender. And the IT stuff that we heard about earlier, there is a practical example of why it's nonsense. Because I have one tax number, and I paid my taxes perfectly happily, but I appear to be two different genders if you look at it in different places for me in the tax records.
Surely that's completely unsatisfactory.
The delay in the UK catching up with good practice in the rest of the Western world and the rest of the civilised world is unacceptable.
Thank you. Lord Faulkner, did you want to come back in there?
I don't think it's particularly satisfactory if there are two systems. I rather agree with Robin and I think the government that if the only issues were these administrative issues, then the idea that you would stand in the way of Scotland making the change to getting a GRC would be unmaintainable. So if that was the only, if it's a bit of administrative, it's not satisfactory, you're right, but as a reason for saying let's exercise Section 35, it would be completely unmaintainable. And indeed, that's reflected by Mr. Jack and Miss Badenoch's statements that their real concern is protecting women and girls, which is a different issue simply from administrative difficulties. And I think we should really focus on the threat to women and girls because that's what the government have done. That's what the central government have done. Could I just also pick up one thing that you said and support it strongly? It was said, I can't remember whether it was by Michael and Naomi, that the effect of the change is that it would allow people who wanted to cross-dress for erotic reasons or who wanted to become to appear to be women for power reasons, that would become permissible under the Act. This is the new bill, in Scotland. That's not my understanding of the bill. My understanding of the bill is you've got to make a statutory declaration saying that you've lived for 3 months in your acquired gender and you intend to continue to live in the acquired gender permanently. So I don't think it's right to say that that is what the bill licenses. It doesn't. And if you make a false declaration, then you're liable to a prison sentence up to a maximum of 2 years. Again, I think there are a large number of trans people who have said the process currently is terrible from their point of view, and I think one should, as it were, recognise that the change that the Scottish Government have made is one that most people accept as a sensible change. Everybody recognises you've got to deal with proper and confidence-inducing protection for women and girls, but that's the dilemma. One shouldn't, as it were, use the process as a means of attacking the trans community.
Yes, and I have to say, I will bring you in a minute, Michael, the use of language around cross-dressing or cross-dressers and people who identify as trans to me are completely different things. Michael?
Well, I think they probably are very different things, but the difference is that there's currently no distinction that's brought out in the bill as it's proposed. I don't think the issue with the bill is necessarily with the fact that you have to make a statutory declaration. The issue is that that's the only thing you have to do. That there are no third-party mechanisms for assessing whether or not the claim that's being made here is fraudulent. And also, in addition to that, there's no real standard at this point for identifying what would constitute a fraudulent claim in this context, because the most important part about that declaration, living in the acquired gender, is completely undefined. And so it's next to impossible for me to see how you could possibly bring a criminal prosecution against someone who you claim to have made a false declaration in this context. And that's both for rule of law reasons and for human rights reasons relating to the clarity of what a criminal offence constitutes. And the reason why we don't have a definition in this bill, but we do have in the GRA, is that the GRA, for better or worse, ties living in the acquired gender to a diagnosis of gender dysphoria. And we may seek to maybe change that to a different diagnosis, but it also ties it to the requirement to produce evidence before a panel who could then make decisions to determine whether or not an application is fraudulent. The issue with the bill as it currently stands is that there are no mechanisms for assessing whether or not an application is fraudulent. And so the presumption that only trans people will make these declarations, will seek to get these certificates, may be a political one that we're willing to make, but it's not a legal one that I could make.
No, I think
legally speaking, there is no limit here except that somebody commits to living in the acquired gender. Now, if that only means a legal status, if that only means having a gender recognition certificate, which seems to be what Shona Robinson indicated, that it would be about changing pronouns and maybe updating particular documents, if that's all that is required, then yes, an erotic cross-dresser could do that, and they probably aren't trans. But the issue is whether or not people who are not trans might use this system, and whether we have any legal mechanisms to prevent that, and we don't right now.
I mean, that is so misleading. Currently, you have to live in the acquired gender for a period of years. That is judged by a gender recognition panel.
Yep.
There's a legal... Wait, can I just finish? That is a legal question that the GRP have got to resolve. So our current system of law requires this judgment to be made, just as it would have to be made in relation to a statutory declaration. That may be a problem, but it's a problem of the existing law. To say that it's changed by this bill is misleading.
And there are no specific requirements placed on the panel. The panel is not limited to anything in particular in judging that.
Okay, I'm going to stop you all there to move on, because my questions are focused around the UK and indeed overseas, so I'm going to go back to that. I'll direct this one again to you, Lord Faulkner, if I can. What are the UK-wide implications of the Scottish Bill's proposed automatic recognition of overseas GRC holders? Could it lead, as the government argues, to overseas citizens in the UK not on the approved list of countries and territories, favouring applying for Scottish GRCs in order to bypass applying to the panel in the UK standards track?
I don't think it will make people apply in Scotland for anything more, because your question, I may have misunderstood, it's put together the fact that the Scottish Bill indicates that they'll recognise overseas gender recognition certificates. So I can't see how that's going to make people go to Scotland to get a gender recognition certificate. I think there may be some problems about are there countries which have no standards at all, but I don't know of any. So in practice, I don't think that's going to be much of a problem.
Do you want to come in there, Michael?
I think one of the points to make in relation to this is also maybe picking up on the point of whether or not the UK government would want to validate or recognise Scottish GRCs. The point really is that that's really for the UK government to make a decision on. And the issue that's being had here is that if the bill as it currently stands is going to create the kinds of pressures that would require them to be alleviated or resolved by the UK government making a political decision, you could see how that could fall within the purview of a Section 35 order, because the effect is on reserved areas rather than areas that are solely devolved to Scotland.
Okay, thank you, Chair.
Thank you very much. Rachel.
Thank you very much, Chair. So my questions are concerning the operation of single-sex associations, safe spaces, what we've called them, and also not just safe spaces, but also, for example, collection of data, say panels. Do we have a gender-balanced panel today, for example? These are the questions I'd like to ask the panel. So I'd like to start with you, Lord Faulkner.
Sorry, order, that's a division in the Commons. Can I just check with members of the committee? Sorry, I have to suspend the meeting. Who's able to come back? Yes. You can't.
The proceeding is currently suspended. 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 The proceeding is currently suspended.
Michael?
Only momentarily, I think.
Okay, I think it's best to proceed because we've only got, I gather, witnesses for 15 more minutes. So I've said order, so we should have started.
Yes, yeah.
Marvellous, thank you. Rachel.
Thank you, Chair. So, pick up where I left off. I want to ask you, Lord Falconer, because you've set out very clearly why you disagree on a legal basis for the UK government triggering Section 35. There's differences of views. One of the things the UK government has said is that they worry there'll be a chilling effect because it's about the operation of the Equality Act. It's not necessarily about any changes to legal rights of trans people. We've all accepted and understood that. But we've also heard very clearly from Naomi and others that there will be a greater cohort coming in to this cohort of people that could seek to access single-sex spaces either in Scotland if they are changing their gender, or else they've got a gender recognition certificate and they then seek to come to the rest of the United Kingdom with a Scottish GRC, which I think, as you've said yourself, there is no longer a requirement to have a medical panel assess that you've got gender dysphoria. So there's a risk profile there. I think that we've all accepted that. So can I ask you then, given all of that, do you completely disagree with the statement that there could be a chilling effect on existing and prospective providers, not just of prisons?
Yes, sure.
Because that's a big organisation with lots of people, highly paid, lawyers, etc., big processes, administrative staff. We're talking about small services. It could just be a very small voluntary service, like the ones I visited when I was safeguarding minister, around the country. Are they wrong to say that there's a chilling effect on how they operate their spaces?
First of all, I completely agree that the effect, the circumstances of the change make it easier to get a GRC certificate under Scottish law if that bill becomes law. There might be more fraud as a result. Whether it has a chilling effect will very much depend upon the way that the law is transmitted in the way that it is operated. If it is absolutely clear, and it wouldn't be difficult to make this clear, that if somebody comes with a Scottish certificate, you can treat that as much less protection against the risks in relation to a safe space, then I don't think it will have a chilling effect.
How can you do that? Surely that is completely against what the Scottish government has sought to do.
No,
it's a gender recognition certificate is a gender recognition certificate, isn't it? That's what they want to achieve with this bill.
Gender recognition certificate is one that means that for all purposes you could be treated as a woman. But equality law says there are certain things that need special protection. In relation to that special protection, there are rules that say, don't worry about whether somebody's got a GRC or not, look and see what the risk is. The position of the Scottish Government, with which I agree, is it's a matter about how that is put into effect in practice. I'm not disagreeing it might have a chilling effect because fraud is easier under this new system rather than the old system.
You're suggesting it would be legitimate for a service provider to say, you've got a Scottish GRC, that's got lower safeguards in it, so I'm going to exclude you from my small service, whereas you, from England, you've got an English one, so it's fine, you can come in because we think that there aren't as many risks. Do you think that would really stand up in a court of law?
Yes, I do think it would stand up in court. What's more, the very example you give, what the notes to the Equality Act said in relation to, for example, the counselling service, it might be legitimate for it to say, we will stop all trans women coming into a counselling session for the victims of sexual violence, because if we let any trans women in, we wouldn't get anybody to turn up. And that was the example given. The law is not a fool. The law is sensible people who will take this and make it work. What you're talking about is the law going bonkers and making people feel the fear that quite legitimately would be there.
I'm talking about the ambiguities because there's a lack of definition about what we mean by sex or gender, with or without a GRC, which can be interpreted. I want to come to Michael. And
Can I just answer?
Yes?
In a sense, that's where the confusion has come. How the courts would look at this is to ask themselves the question, is what's been done here, say ban all trans women from particular single-sex services, is that a legitimate way of providing adequate protection? And the notes to the original Equalities Act make it clear that might be appropriate. The courts will be sensible, and they will be particularly sensible if they get sensible guidance from both governments and the Equality Commissions.
I really want to ask also Robin whether she thinks it's right that we would ban all trans women from services, but then I want to come back to Michael as well. So
Perhaps
Michael,
Robin can answer the question being
Yes.
directed at Robin, not you, Lord Faulkner.
yes.
Sorry, which way round did you want to do that?
I want to ask you, Robin. Lord Falkland's just suggested one way of helping small service providers would be for the government to write a guidance document that said you should ban all trans women from these services.
He didn't say should.
Possibly could.
And that's the
Would you?
position.
Do you think the government should do that?
I mean, that's,
Forgive me. I mean, you're asking me a policy question, which.
Okay.
So,
Yep.
let me take an area in which I'm experienced, in that I represent a number of rape crisis centres, for example, who have come to different decisions. Now, the overwhelming position for rape crisis centres in the UK is that they are inclusive of trans people. They are permitted to be exclusive, and they can be if it's a proportionate means of achieving legitimate aim. Lord Faulkner a moment ago was talking about counselling services. Let's assume that there is a level of risk of someone who is a counsellor. One can imagine the circumstance of them being left with a vulnerable person to counsel the vulnerable person. Well, we have systems like DBS checking where the organisation would put...
We're very short of time, but I really want to... perhaps you're not going to...
Blanket bans are very difficult to justify.
Yes, they are, indeed. And Michael, you wanted to come in.
But not impossible.
Yeah, so, I mean, I think the first thing to note here is that we really do need to distinguish between the legislative framework here and then guidance that is introduced.
Yes.
Because if the guidance is incompatible with the legislation, it falls every time.
Yes.
And so the question is not really whether or not we could come up with a sensible guidance outcome. The question is whether or not that sensible guidance would withstand legal scrutiny. And when it comes to a discrimination case that might be brought by someone who has been excluded, there is nothing in the Equality Act that states that it is acceptable to ignore the fact that somebody has a gender recognition certificate. There's nothing there that says that it is permissible for a service provider to ignore the legal sex of the person who is requesting access to a service designed for people of that legal sex. In fact, I think the idea that a gender recognition certificate will not make any difference in the proportionality test here just wouldn't stand up to water. It is clearly a relevant consideration that would have to be taken into account both by the provider of the service in assessing whether or not they're legally permitted to do this, and also by a court. A court will have to look at that to assess whether or not what has been done here is proportionate. Now, I think the other point to draw out in terms of blanket bans is that, yes, blanket bans are very, very unlikely to pass a proportionality test, because there will be some circumstances when a court will decide that the blanket ban is disproportionate. But that's why we have legal mechanisms in place for certain things that we think, if this was to happen, it would be so bad, it would be so awful that we need to have an absolute prohibition. So that's why we have an absolute prohibition on cruel and degrading treatment. It's not a proportionality assessment. And right now, everything that we're dealing with here is dealing with proportionality assessments, which means you cannot have blanket bans on any of them. If you want a blanket ban that says no rapists in female prisons, and if you want to ensure that, and that might say, look, no biological males in female prisons.
Michael, I'm sorry to intervene, but we do have blanket bans for things like religion, who are entitled, for example, if it's a tenant of the religion, not to have a trans priest. Now,
yes, no, they're absolutely, but
there is an example.
What we're dealing with here, services, associations, and schools, there are no blanket bans. Everything is subject to a proportionality.
Yes, that's right, and that's why I wanted to challenge Lord Falconer, really, because obviously the UK government's argument was this would have a chilling effect, because we've heard two diametrically opposite arguments just from two legal brains on this panel. So we're actually expecting small services to then navigate through all of this, be worried about where they are with the courts, rely on the courts, which are always sensible.
I mean, the relevant point, so I will be quick. The relevant point here is also that if you're dealing with concerns in relation to safeguarding, The point of safeguarding law that relates to safeguarding, is that you have to deal with the exceptional case. Because if the exceptional case was to happen, it would just be so awful. It would be so incredibly awful that we need to have a system in place that prevents that from ever happening. Now, if we think that, for example, the rape of a female inmate in a prison is one of those categories, then you need a blanket ban.
Yeah.
There's no other way to do it.
Okay.
And you can't do that under the current legal framework.
No, you can't do it in the current legal framework. I want to bring in Naomi, please.
Yes, I just want to illustrate or draw out how the disagreements on this panel are illustrative of the chilling effect, especially for small organisations. And it may well be, one might hope, that most rape crisis centres in the country would wish to be able to provide single-sex services for traumatised women. Many of them are not doing so. It may be that they are genuinely persuaded that there is no need for such a thing, or it may be that they're frightened of litigation. And I suggest that there's good reason to suspect the latter is what's going on in many cases. Michael says a GRC will be relevant to the determination whether it's proportionate to exclude someone from a particular service. I'd part company on that, so we have yet another disagreement even between two lawyers who are mostly pretty aligned on this, because I would say a gender recognition certificate, a certificate making a counterfactual declaration about your sex, which is what it is, has no bearing on anything, especially under the proposed regime in the bill, where such safeguards as there are in the Gender Recognition Act are removed. But really, in any event, they don't tell us about risk. It doesn't tell us about bodies, because there's no requirement for surgery. It doesn't tell us very much, and less under the bill, about reason for wanting a gender recognition certificate. All it is a certificate making a secret certificate that nobody's allowed to ask you about or tell anyone about, making a counterfactual declaration about your sex. It's not relevant to the risk you present, and it's not relevant. And something that I want to come back on is these debates do tend to get very hung up on risk. And fundamentally, many of these questions are not about risk, they're about comfort and dignity and privacy.
Which is why I opened my session just talking about not areas where we're talking about the boardroom and gender pay gap and panels, and obviously we haven't even got into all the other things. But you're absolutely right, it's not just about the risk, although that's vital.
In there.
I know
fundamentally, it's unimaginable that anyone who has concerns about privacy and dignity is going to have their mind changed by a certificate. It doesn't.
How are we doing for time?
We're not doing well for time. The panel indicated that they'd quite like to finish by 10 past, although that was not a hard stop.
Yes.
If you have any further questions, can they be snappy?
Did you want to ask any questions?
No, I'm done. Annam, did you want to ask a further question?
If Annam wouldn't mind, because she did have quite a long time earlier, if I may possibly ask a final question then. We did talk about indirect and direct discrimination and the Haldane judgment. I mean, there's just so much here, but perhaps I could just bring it down to one thing, which is that if Lady Haldane is right, this is what our committee experts have suggested, if Lady Haldane is right, then there might be no way to establish any sex-segregated services at all, because the tests needed to be met to justify their establishment simply cannot be met. So it's how do we demonstrate that a joint service would be less effective than a separate one if the separate ones include biological males and females? I think that's the thing that I'm wrestling with, which I know you won't be able to answer in a minute, but perhaps if you could...
I mean, if you are saying that the effect of Lady Haldane's judgment is to completely negate all of the proportionality tests in the Equality Act, that is certainly wrong.
I'm just asking the question.
I think that is certainly wrong. What's more, Lady Haldane plainly did not intend that, and if there was an appeal, that would certainly be made clear.
It does nothing to take away the provisions in the Equality Act that allow, if proportionality tests can be made, for there to be exclusion of trans people from a particular service.
Okay.
I think that's right, in the sense that the proportionality tests the tests remain the same, and the text broadly remains the same. But if Haldane's judgment is correct, that means that every reference to sex in the Equality Act, because Haldane does not differentiate within the Equality Act. If that's correct, then every reference to sex within the Equality Act means legal sex. That means that you're not setting up separate services for biological women, you're setting separate services for legal women.
Yes.
And so the exclusion rules are, broadly speaking, the same rules. Now, whether they're met is going to be slightly separate, but whether you can even set up one of these services, if Haldane is correct, there's going to be a difficulty in answering that question. And another difficulty in terms of direct and indirect discrimination, since we're bringing it up, if Haldane is correct and sex means legal sex, then every single discrimination case that has been decided on the basis of direct discrimination on the grounds of sexual orientation is wrong. Every single one of them. Because sexual orientation in the Act is defined by someone who is attracted to a member of the same sex, whatever that means, a member of the opposite sex, whatever that means, or either the same sex or the opposite sex. Now, I'm a gay man. I am not attracted to a legal category. I'm attracted to a biological category that may be a subset of a legal category. And what that means is if I get fired because of my sexual orientation and seek to sue for direct discrimination, the argument will be, well, there is somebody here who is, you don't meet the standard here of direct discrimination. You meet indirect discrimination standards because it's more likely to affect people who are attracted to one biological category. So if that's correct, and I mean, that would be a radical change to how we understand the law in this area.
I understand the point, but I think, therefore, what you've shown with an erudite, logical argument is that sex does not always mean the same thing, section by section by section through the Act.
Well, that's just not how statutory interpretation works. Statutory interpretation, there is a definition set out in the Act, and that applies across the entire Act.
Thank you for that. Thank you for that. And Naomi, if I may ask you.
A similar point in relation to single-sex services. One of the conditions that makes it lawful to provide a single-sex service is that is a service that is only needed by one sex. Now, if sex means women plus men with gender recognition certificates declaring them to be women, there is no imaginable service that is only needed by that category, because it's not a natural category at all.
Yes.
Cervical smears are only needed by women, but suddenly that's not sanctioned by...
Cervical smears might be needed by transgender men. But they are...
Well, it depends. So if the Act says that a transgender man, with or without a gender recognition certificate, let's say they have a gender recognition certificate, if the Act says that they are legally male now, then yes, there will be certain men, legally men, who need vital smears. But what it would also mean, though, is that that person can now no longer sue for pregnancy discrimination, because the Act protects only women who become pregnant.
But fundamentally, that means that the provision that says you can provide this service for women only means you're providing it for women only, so you're not providing it for women who think they're men. Even though they need it, you're providing it instead for women who know they're women and men who think they're women who don't need it. You're not providing it for the women who think they're men who do need it. And anyway, there is no... The permission to provide a service for one sex only becomes meaningless because it's women plus something that isn't women.
Given what we've seen,
there is no service that category of people all need and nobody else.
It's really hard to see how. I mean, there's four of you, and this is so complicated to navigate and so different from all four of you in different, very technical ways. It's really hard to disagree with the statement that there will be a chilling effect on providers of single-sex services.
Yeah, it's difficult.
Can I possibly? So that's it. So we can't make life more generous for transgender people.
Here, with respect, Lord Falconer, we're talking about the legal ramifications.
I'm talking about the legal ramifications.
I'm trying to tease out with this particular
and
very targeted. I agree we should try and make life better for transgender people, but I also want to make life better for women who need single-sex spaces and need to be safe. I want to balance the two. The two have to happen at the same time. And we don't raise up one group by trying to take away rights and protections from another. But I think that's a second policy question, if I may.
Haldane judgment applies to the Act, the Equality Act, as it is now.
Yes, I know, but if you remember, when I started my line of questioning, I reminded from my briefing that I've had, one of the reasons of the UK government was to say that it's about the operation of the Equality Act, given the new cohort of people that will be coming into it.
No, but to justify using Section 35, you have to have an adverse effect on the operation.
You don't think a chilling effect is an adverse effect?
No, forgive me. What we've done is explore the implications of the Haldane judgment on the Equality Act as it is now.
Yes, I understand.
Not with what the difference the GRR might make to it. Now, I believe I have practiced for 30 years in discrimination, and I have watched judges take the Equality Act, and I really enjoyed reading Michael's paper, a lot of which sets out some of the difficulties with the Equality Act as it is now. That's his point in some points. I disagree that the GRR makes a difference. But
make them worse.
What we've tried to do in the Equality Act is express ways of balancing in there are other protected characteristics, but we're obviously focused on sex. Sex is not, as I think what we've managed to demonstrate, is that sex is not simple, not straightforward.
No.
And what happens when we try cases, very quickly on equal pay, there is one poorly argued judgment on what the effect of a trans person on an equal pay claim is. It's poorly argued because it was only argued by one side of the case in the AT. So there is effectively no useful case law in that area. There will be, ultimately we'll get to it. But actually what sex is complex, and that's what we've shown. We can try and write good law. People have tried to write good law. Partly we have to trust the courts to look sensibly at the particular provision. So there's a provision that says, as Michael is saying, a woman has a right to pregnancy rights. Now, is a pregnant trans man to be treated as a woman if they go to their employer and say they want pregnancy rights? I would say yes, because they're in an unusual circumstance. But until that occurs in front of a tribunal, we won't know.
Yeah.
Can I just? This is absolutely at the nub of it. The solution the law has adopted in relation to this is we will recognise transgender people in the gender that they choose. But if there is good reason for excluding them from a benefit that, for example, women and therefore trans women have, then the law will allow that if there's a good reason for it. You're so right that you can't be certain that will always come to the right answer. But that is the solution that equality law has adopted.
I think we all...
Can I just finish the answer, please? As far as the change in Scotland is concerned, that makes it easier to get a certificate, but those people who've got to decide whether they exclude trans women or trans men from men or women's spaces will know that. It will be difficult for some, but there are no easy answers to that. Should we abandon the basic approach that the law has taken, which is you are allowed into a women's space if you're a trans woman, and similarly a man, and that doesn't depend on whether you've got a GRC certificate. You're regarded as a trans woman by the law, even if you don't have a GRC certificate. I don't think we can abandon that because there's no alternative.
I think Naomi wants to come in, but the answer to your question is no, we shouldn't abandon it. We should find a way through it. But you're making two extreme, sort of very extreme things,
No,
and
I'm
I'm
not.
not advocating either of them. But Naomi.
Lord Faulkner seemed to be saying, correct me if I'm wrong, that there was already a right in men who identify as women to access women-only spaces even if they don't have a gender recognition certificate.
You can be a victim of gender reassignment discrimination in a whole variety of ways. You need a GRC to get into women's spaces.
But exclusion from a women-only space, and this is a really important point, gender reassignment is a protected characteristic. and you're protected from discrimination on grounds of gender reassignment. But if you are a man who identifies as female and you don't have a gender recognition certificate, you are legally male, as well as literally male.
Yes.
And therefore your exclusion from a women-only space is not a matter of gender reassignment discrimination. It's a matter of sex discrimination.
But you're allowed to do that. You're allowed to do that.
You're allowed to do that.
Exactly. And you're always dealing with the balance between, on the one hand, the principle of
We are
protecting.
going to have to wrap this up very shortly. Michael, did you want to make a final
Yeah,
comment?
the only point I'd make is that in that context there, the person who is being excluded on the grounds of their legal and biological sex. If somebody has a gender recognition certificate, the claim that they can make, they can no longer bring a claim of sex discrimination because they're legally of the sex of the service. They can bring a claim of gender reassignment discrimination. And so what that means then is services will be subject to a proportionality test. Now Naomi argues, and I think persuasively argues, although we disagree, that the fact that you can set up a single-sex space means that there will always be a justification for exclusion. Now, I think that might be true, it might not be true. But what we know for certain is that a gender recognition certificate gets you an automatic right of access to associations and schools because there are no provisions within the Equality Act that permit associations or schools to discriminate.
Say, you mean things like golf clubs or,
So a women's only reading group, or so a book group, but there could also be a group that's set aside, privately run by women who are victims of assault.
Yes, that's a slightly separate thing, isn't it? But association.
So the point would be that might not be a service. That could be an association. The service is open to the public. An association could be a private group of women over numbers of 25 where they regulate their membership, and the association could be a support group that they regulate their membership for people who have been the victims of assault. Right now, it is true. Right now, someone with a gender recognition certificate, in my view, will have a right of access to those associations. And the Gender Recognition Reform Scotland bill gives more people access to those certificates. Now, schools, there's no chance right now, in any practical sense, that there will be someone who is a GRC holder who is currently going through school. But if you lower that age to 16, that absolutely will happen, and they will have a right of access. That's how the law will work on that area.
Yes, understand. Thank you.
Thank you for that. Order. Can I just thank the witnesses?
The proceeding has ended. 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 The proceeding